Hi, I'm Dr. Shadi Maganoe. I am a senior lecturer in the Wits School of Law. Today I'm going to be talking about a paper I'm working on that speaks about how our constitution facilitated state capture. Where does my argument come from? So if you look at the negotiators or the founding fathers and mothers of the constitution, during the negotiation or the certification of the constitution, when in certain instances they were not certain about which power to devolve between the legislature and the executive, they often defaulted towards giving the power to the executive because at the time it probably seemed like something that was practical because governance was vested in the executive. In hindsight, this created an imbalance of power and an over-concentration of power in the executive. Why? This was evident in the Zuma years. If you look at what President Zuma did in terms of the appointment of ministerial offices or ministerial positions, he wasn't wrong. Practically speaking or technically speaking, he was acting within his constitutional powers. Another example would be President versus Public Protector. In that case, the Public Protector recommended that a commission of inquiry be instituted where it was going to investigate state capture. The president argued that this was his prerogative as the constitution gave him those powers. So technically speaking, again, he wasn't wrong. The constitution gave him those powers. So his argument wasn't wrong. Then the court was faced with a difficult question. What happens in an incident where a commission of inquiry needs to be done and the president, who has the power, is the subject of the inquiry? While the court made a decisive decision in terms of upholding accountability, it became problematic in the sense that it left a gap or a question as to whether the powers of the executive or the president in that sense were not encroached upon. So if you look at the powers that the president has, it's based on the South African model of the separation of powers. So hence why I'm arguing that our constitution basically facilitated state capture through the over-concentration of power in the president. So the president or the executive is given too much power in terms of appointments, in terms of certain decisions that they can make without consulting either the judiciary or the legislature. What makes it even more problematic is the interdependent relationship between the legislature and the executive. So for that reason, our model, or the South African model of separation of powers, created an imbalance and provided an over-concentration of power on the executive. The legislature is not able to effectively hold the executive accountable because of this interdependent relationship. Members of parliament, or the people we elect into parliament, become members of the executive. Now, also this comes from our electoral system. We don't elect individuals, we elect parties, and then they put people in parliament. So once people are in parliament, they choose, or political parties choose who to put in parliament, and then these people end up in the executive. Parliament can't hold them accountable because they are members of political parties. So this becomes a problem when it also comes into the issue of political will. So what the former President Zuma did with his constitutional powers is something that I think the negotiators of the constitution didn't think about, or they didn't think that someone wouldn't use those powers in good faith. And that's what we saw in terms of state capture. Thank you.